My name is Joe Bach, and I'm the president of the Rutgers Federalist Society. To my left is our events director, Eugene Sherman. And we would like to thank Hans von Spakovsky coming here from the Heritage Foundation in Washington, D.C., and Professor Alan Hyde from Rutgers Law School. Now Eugene Sherman will introduce the participants.
Mr. von Spakovsky is with the Heritage Foundation. Mr. von Spakovsky is a senior legal fellow there. And the Heritage Foundation during the Cold War era helped prevent the spread of communism abroad. And today the Heritage Foundation is for individual freedom, is for small government, is for strong national security. Now, Mr. von Spakovsky has served as counsel with the Justice Department and has served for 2 years as a member of the Federal Election Commission. And Mr. von Spakovsky has appeared in Fox News as well as in major publications such as the Wall Street Journal. Mr. von Spakovsky has his bachelor's from MIT and his JD from Vanderbilt University. Professor Alan Hyde teaches here at Rutgers, as some of you may know. Professor Hyde teaches immigration law, labor law, employment law, as well as contracts to 1Ls. Professor Hyde, prior to coming to Rutgers, has served on the National Labor Relations Board. He has represented them in federal courts of appeals. And Professor Hyde has also been a visiting professor at a number of prominent law schools such as Yale, NYU, Columbia, Cornell, and many others. Professor Hyde has his bachelor's from Stanford and his JD from Yale.
I will now announce the issue of the case. On April 23, 2010, Arizona Governor Jan Brewer signed into law Senate Bill 1070, also known as the Supporter Law Enforcement and Safe Neighborhoods Act. Some of the relevant provisions of SB 1070 are a requirement that during a lawful stop, law enforcement officers must determine immigration status of individuals that they reasonably suspect to be illegal aliens. A provision that illegal aliens who violate federal alien registration laws, which require aliens to register and carry their documents with them at all times, are now subject to arrest and penalties under the Arizona Criminal Code. The bill also includes a prohibition on illegal aliens without work authorization from applying for work, soliciting work in a public place, or performing work in the state. It also contains laws prohibiting the transportation, harboring, or encouraging of illegal aliens to remain in the United States. Finally, it also requires employers to maintain a record of an employee's e-verification eligibility for either the duration of employment or at least 3 years. The United States Department of Justice and other legal organizations filed suit in the United States District Court for the District of Arizona, arguing that SB 1070 interferes with immigration regulations exclusively vested in the federal government. On July 28, 2010, Federal Judge Bolton issued a ruling on the Justice Department suit in United States of America versus Arizona. Justice Bolton wrote that issued a preliminary injunction blocking important provisions of SB 1070 from going into effect, including the requirement that the police check the immigration status of those arrested or stopped. We will now begin our debate. Each participant will have 20 minutes. Following this session will be a rebuttal from each participant. Finally, we will conclude the event with a question and answer period. Professor Hyde will speak first. Thank you very much.
Thank you, Joe. Thank you very much to Mr. Spakovsky for coming here and joining us, and thank you to the Federal Society for having this debate and for inviting me. Can you hear me all right? I'd like to hear the laptop and project the test. I wish to restrict my remarks entirely to the question of the constitutionality of the Arizona statute known as SB 1070. I do not propose to debate what should be the immigration policy of the United States. I'd be happy to discuss that with anybody in this group or with the Federalists at another time, on another occasion. not all of us in the room agree on what should be the immigration policy of the United States. Not all conservatives agree on this question. Some of you are libertarians who may regard any restriction on human mobility as a governmental interference with efficiency-enhancing contracts between willing workers and employers. Some of you want law to be more friendly to business and are concerned about immigration laws, mainly to the extent to which they deprive business of the ability to hire global talent. Some of you may be cultural conservatives who are very concerned about the potential impact of immigration on American politics or culture or institutions. But today I wish to speak to all of you. I hope to convince you that whatever your preferred immigration policy, under the Constitution it must be federal policy, applicable to the entire country. There is no place under the Constitution for Arizona to have an immigration policy, for roughly the same reasons that there's no place for Massachusetts to have a foreign policy. Now, one way of demonstrating this might be a very simple thought experiment. Imagine that some state whose politics you don't like enacts some immigration laws that you really don't like. For example, just last weekend, the Los Angeles Times USC poll reported that 59% of Californians think that an unauthorized migrant who enters without inspection but then works for 2 years should be receive lawful permanent residence in the country. That policy, California is not free to adopt for roughly the same reasons, I will argue, that Arizona is not free to adopt its. But apart from that thought experiment, I will proceed in 3 steps. First, I want to examine, as closely as time permits, the actual provisions of SB 1070. Much of the public discussion of this statute on both sides has been by people who've either never read it, including the Attorney General of the United States in a famous submission, or people who are misstating it and spinning it for various purposes. But this is a law school, and we have the statute here, so we can read it. Secondly, in looking at the statute, I want to focus specifically on 5 provisions, some of which Judge Bolton enjoined and some of which are pending. The legal situation is a little complex. Judge Bolton split the preemption challenge, which will get most of my attention today, from the challenge based on individual rights and liberties. As soon as the statute was passed, the federal government sued to enjoin it, raising only preemption issues. And a bunch of immigrant advocacy groups joined the suit, raising preemption issues and individual liberties and rights issues. So Judge Bolton split it up. She so far has considered only the preemption issues, and as Joe correctly mentioned, she's enjoined enforcement of 4 specific provisions of SB 1070. The state of Arizona is appealing that, and that appeal will be argued this Monday before a panel of the Ninth Circuit. She has not yet ruled on the liberties issues, which I think are much more difficult, particularly brought as a facial challenge to the statute. So I will look mainly at the preemption issues, which I think are not difficult, actually. I think this is an easy constitutional case, as I hope to show you. And will not look so much at the liberties issues, although they are intense. I will focus on a new immigration practice, that is the practice of mandatory status checks of individuals, and 4 new Arizona state crimes created by the statute, none of which is now a federal practice or a federal crime. Secondly, I will review the constitutional law on state powers to legislate about immigration. And I will show you that most, actually really all, I would say, of the problematic aspects of the Arizona statute have actually come before the court in earlier immigration preemption cases have been found to be unconstitutional if adopted by a state. That's what Judge Bolton found in this case, unsurprisingly in my view, and that's what the Ninth Circuit will affirm, I predict. Thirdly, I will examine very briefly the rights challenge to the Arizona statute on which Judge Bolton has not ruled, and I will conclude with a brief historical postscript. All right. So first, what does Arizona SB 1070 actually do? The statute is 19 pages long. It amends at least 10 different titles of Arizona statute. So you can't go to Westlaw or Lexis and just find it. I poked around online and I found this thing which is marked unofficial, but I believe, and Mr. Spakovsky confirmed that this is actually the version that was adopted. The procedural history is complicated. It was passed by the Arizona Senate, and then there was attention drawn to some provisions which were particularly constitutionally problematic. For example, as you see, the statute originally applied to all lawful contact between law enforcement officials and individuals, and people said, what if it's voluntary? What if you go in and apply for a parade permit? The police department has to check your immigration status if you apply for a parade permit, and not wanting to go that far, the Arizona legislature then, it was a week later, 10 days later, passed some amendments in green in this version to make it clear that the statute applies to stops, detention, and arrests. There's a severability clause, so only 4 provisions have been enjoined from going into effect. Others are under litigation. Some provisions are not objectionable at all, but I'll look at the ones that receive most of the attention. That is the one new practice, mandatory status checks, and the 4 new Arizona states, which I'll turn to in a second. All right. The new practice is the practice of what people call mandatory status checks. That is, requiring routine demand of proof of immigration status of all individuals stopped by local or state police where those police have, quote, reasonable suspicion, that's a term of art in federal constitutional immigration law, that the individual is undocumented. Then they must do a mandatory status check with federal officials. Federal law, this is a change. Federal law does not currently require or permit federal or state law enforcement officials routinely to demand such documentation. Many federal officials, as a matter of their agency's policy, are directed not to ask for immigration status. When the Department of Labor is investigating wage violations, an employer that doesn't comply with labor standards, those hurt everyone working there, Americans, green card holders, and we do not want that investigation to be sidetracked by demands of threats of immigration response. We want them to be able to get whatever evidence they have. Other federal officials, the FBI, prosecutors have discretion whether or not to ask about immigration status. If you're trying to break up a drug ring, you may want the form to come clean at that point, and you may not want to get distracted by immigration issues. By contrast, the Arizona statute requires all state and local police to inquire about immigration status every time they have reasonable suspicion to do so. The mechanism for doing this is a little bit complicated and involves 3 different portions of the legislation. First is B up there, for any lawful stop, detention, or arrest where reasonable suspicion exists, a reasonable attempt shall be made where practicable to determine the immigration status of the person. Okay? This is one of the provisions found preempted by the district court. The reason it's mandatory is you have to read that with 2 other sections of the statute. One of them is Clause A that's sitting up there. I hate to be pedantic about this. No official or agency shall limit or restrict the enforcement of federal immigration laws to less than the full extent permitted by federal law. Okay? In other words, in Arizona, federal officials do not have a direction like that. As I say, federal law enforcement officials have discretion, depending on what they're investigating, whether or not to ask for immigration status. Arizona officials don't, because they're directed to enforce federal immigration law to the max, and that means fighting possible violations. And the third provision that reinforces this, I'm not sure you can put the text up, but a little later on, the Arizona statute has a very unusual provision for private citizen suits if you complain that Arizona state officials are not enforcing the statute to the max. It's a rather unusual provision. So you put that together and you say every Arizona official is directed to enforce federal immigration law to the full extent permitted. If they don't do it, Arizona citizens can sue them for dereliction of duty and recovering damages. And what we want them to do is to check every time there's reasonable suspicion. So that's why it's quite a change from the existing federal practice. Now, much of the early criticism, as you probably know, focused on this concept of reasonable suspicion that someone is out of immigration status. What does it mean to say you have reasonable suspicion that someone is out of immigration status? People who overstay their visas or who come in on a student visa and work, they look just like everybody else. There is no ethnic or racial group that is statistically particularly likely to violate a visa. So the charge has been made that in practice, what SB 1070 will amount to is racially differential application of reasonable suspicion. And it's alleged that the police will think that any individual who looks Mexican and is stopped by the police will be thought to be under reasonable suspicion of an immigration violation, and the federal authorities will be checked, whereas non-Latin people will rarely raise issues of reasonable suspicion, even when statistically they might well be out of immigration status. I believe this charge is correct. The statute does require consideration of racial and ethnic appearance, and the key passage for doing so is this passage at the end of paragraph B that we have up there. A law enforcement official or agency, yada yada, may not consider race, color, or national origin in implementing the requirements of this subsection, except to the extent permitted by the United States or Arizona Constitution. Okay? Supporters of the legislation describe this as the statutory prohibition on racial profiling. It is not. It is exactly the opposite. It is the statutory requirement of racial profiling because if it were a statutory prohibition on racial profiling, it wouldn't have an except clause. If you wanted to pass